Good morning and welcome to today's webinar by Field Fisher and Gardner Law. Before we begin, I would like to point out that this webinar will be recorded. You will, however, not be heard or seen at any time. Questions are, of course, more than welcome. If you'd like to ask a question, just type it into the question pane on your control panel. The presentation, as well as the recording, will be sent to you after the webinar. And today we have two wonderful speakers, Jesse Atkins from Gardner Law and Andreas Driva, who is a lawyer at Field Fisher, Germany.
Great. Well, thank you. Thank you, Freya. I'm excited to be here. I'm particularly excited to be here with Andreas, who's been great to work with on this presentation, and a good reminder of how lucky we are at Gardner Law to have Field Fisher as a partner in these activities. So in thinking about presenting on the topic of medical device transactions in Europe, Andreas and I spent some time considering how we could both present it in a way that would deliver valuable information, but also not bore you as an attendee, and that would be a little fun for us. And so what we decided to do is, my being a recent addition to Gardner Law, but having formerly been in-house counsel, engaged in a fair number of due diligence activities. We had talked about the fact that it would have been absolutely ideal if I had had an expert like Andreas to be able to ask questions of, utilize his wealth of experience and expertise in foreign corporate transactions. And so while I didn't have that luxury while I was in-house, I'm going to play a role of myself some time ago, imagining myself in-house and utilizing Andreas's expertise in diving into what my fictitious company is looking at from a transaction perspective. So travel back in time a few months with me to my in-house counsel days, and I'm going to dive right in and begin with the question. So Andreas, and for everybody, you can see here the experience that we're working with here. So the role that I am is I'm in-house counsel, and my executive leadership team is particularly keen on expanding into Europe. Our competitors are all expanding into Europe. There's a lot of discussion about why our medical device company may benefit, and what kinds of hoops we may have to jump through in order to do that expansion. And I guess the question I'd start with to you, Andreas, is why? Why should we expand to Europe? And if you could expound on that, it would be very valuable information for us.
Yes, Jesse, thank you very much for the introduction. And yeah, it was great fun to prepare that with you. And thank you for that opportunity to pitch to you and to your company. Not only our law firm, but also why should you expand to Europe? I have gathered a few numbers here. As you can see, the medical market, market for medical devices in Europe accounts to over a quarter actually of the world over turnover. And Germany actually thereof is again more than a quarter. So we're talking about quite a significant market here. You have, which is for Americans maybe not so special, but you have not a unified, but at least a common market that allows you to have one one certification for your product, so it can be marketed throughout Europe. So it is a substantial market, and it's a very mature market. For example, in Germany, 90% have a statutory health insurance, and the other 10%, most of them are privately insured. So that shows that you will get paid for your products. Also, it's a good market to expand to for your company, because you will have access to a lot of experts throughout Europe, with access to the universities and also possible subsidies that are granted by the states in Europe. And therefore, I think it's absolutely no question at all that your company should make that step to Europe.
So on that, if I could ask one follow-up, you talked about expert professionals. Does Europe represent a market where you see, for medical device companies, significant uptake of new or breakthrough technologies that will have access to centers that you think would be that would present reliable customer bases for us?
Definitely. I mean, I would say probably the same areas where research is being done as in the US. I think research, like there are differences in the various stages. For example, if you look at trials, these are more mature in the US. You have a better chance to have a broad trial in the US being conducted. But the development of new medical products in Europe is I would say same level as in the US, with the same topics also at the moment, like artificial intelligence as well, and as we call it, Industry 4.0, so meaning interactive robotics. You have 3D printing for devices, and it's, I would say, the same topics you have as in the US.
Excellent, excellent. So let's imagine for a moment that I'm able to convince my executive team that yes, this expansion is worthwhile. The first question they're going to ask back to me is, what's the structure of this? What type of a transaction should we be looking at? And so I guess I'm wondering, what sort of transactions have you executed alongside your clients, and what are the benefits and pitfalls of those various types of transactions?
Yes, and the easiest way how you could approach the European market would be the use of a distributor, that you look for a contractual party in Europe that would distribute your products. I think there is not too much to be considered, obviously, as always, when you are in commercial law. We come to that later, as again, it's a question of the applicable law. We have special protections for commercial agents in Europe, for example, so you have to be careful that it's not structured as a commercial agent. But that would be the easiest way. If you want to have a presence of your company entity in Europe, you could consider to have a subsidiary, which is not an own legal entity, but just a branch. Sorry, not subsidiary, it's on a branch. You would consider a branch, and the branch would not have an own legal entity, but would only have an entry in the commercial register, for example, in Germany, where you would say your company has a branch in, let's say, Munich. These are the people that are authorized to act on behalf of the branch, and that's it. The problem with that is, I mean, it's easy, there's no funding requirement. The problem with that a little bit is any change in your US entity then has to be filed in the German register as well. And also the fact that it's an US entity means that obviously the representation of that entity is governed by US law while you are in Germany. So that's sometimes a little bit difficult. That's why usually you would see that the subsidiary is being set up. A subsidiary is then very easy to handle because in the respective European country, for example, Germany, the people would know that entity, how it's represented, would understand it. It's also easier for accounting purposes because you really know, okay, these are the assets of that subsidiary or the IP or the employees, and you don't have that allocation problems. From a tax perspective, it's a little bit more complicated than to make dividends. but it's still due to, for example, with between the US and Germany, you have a friendship treaty with a double taxation treaty, so that would protect you to against excessive taxes here. And the latest possibility is obviously the acquisition of an existing entity in a European jurisdiction.
So let's talk about then, what are those key considerations that we're going to have as we're weighing those, right? I mean, I think acquisition is one of the directions that we had originally thought of, and I think we probably fall into that trap of thinking that there are only one or two different kinds of transactions when you're expanding into a foreign country, but you point out quite a few different ones. But what are some of the other considerations that you'd recommend we have in mind as we evaluate our options?
Yes, as said before, I think tax is definitely the main consideration you have here. You would have here the benefit with the subsidiary, with the branch. I will get it straight now. With the branch that it's not an own entity, and therefore you would think it's not a taxable entity, but that's unfortunately not the case. So you still have to submit your tax filings for the branch in the European country as well. And but you don't have any profit distribution if profits are then paid to the main company in the US. So that's more tax efficient. But as I said, due to the double taxation treaty you have with various countries, usually it's not such a big problem. And the question would then be actually that you make an analysis of how many profits you are going to make, and how are you going to distribute these, because obviously you still have a lot of inter-group transactions as well. So that tax picture is rather complex. For staff and labor law, again, it's a little bit easier if you have a special particular entity in Germany that is the counterparty and the employer here. That's easier to understand. That applies to all contracts as well, and you also would then benefit from a shelter for possible liabilities, because obviously it's not the US entity itself that is liable, but only the limited liability company in the European country. And yeah, it would also help you to have a better presence in Europe, usually because obviously that entity shows that you have more substance and the intention to stay longer in the market.
So I see that you've highlighted intellectual property as one of the considerations. I certainly don't want to turn this into a long, in-depth discussion. We could spend hours talking about the various implications of intellectual property when we're crossing borders with the kind of technologies that we're discussing. But could you just give me a couple of thoughts that you have about protecting intellectual property? Because that's certainly one of the things that's going to be on my company's mind as we contemplate this move. Have we lost Andreas?
Yes, it seems like it. He was experiencing some technical issues and had some connectivity problems, but I'm sure he'll be right back.
Okay, let's. Andreas is certainly the expert on this topic, so I think we're better off waiting for his connection to resume.
Yes, exactly.
I will say while we wait, the presentation's got two parts. One of which is interaction between Andreas and myself. The second half then is a discussion that I'll lead regarding due diligence activities. So if we're not able to get Andreas back right away, I'm happy to jump over to that part of the webinar.
That would actually be fantastic. We had one question from the audience that I would like to ask you now that we have the time.
Okay.
And that would be, are there specific questions that are valuable to ask during due diligence?
Yeah. Yeah, and you know what? I almost think that question might be best answered after I go through. We've got quite a few slides on due diligence. So, Fry, if you wouldn't mind holding on to that question for a little bit, and we can do that. But while we wait for Andreas, I'm happy to jump forward in this presentation and jump into due diligence right away. We can pick up with Andreas when he's able to rejoin us. These are just this is what happens in the
Sorry to interrupt again, but I think he's back. Andreas, we can't hear you yet.
Can you hear me, Jason?
Yep, we can now.
Okay, sorry about that.
That's perfect. That's what I was just saying. This is what happens when a pandemic takes over the world and we all start working from home. So it's perfectly all right.
Sorry about that. Yes, intellectual property. The last point I wanted to make is obviously you can consider when you develop intellectual property in Europe that you have the access to the universities here and the subsidies to develop it. If you do that, obviously that exploitation of such intellectual property is subject to restrictions then again, and also that has to be considered.
Okay, excellent. Well, thank you. So I think the next thing then to consider is, you know, what's on our mind if we're going to go the route of a merger or an acquisition as opposed to a subsidiary or branch transaction?
Yes, mergers and acquisition. If you intend to have an acquisition or a merger, first obviously you have much more complexity. So that is something you should be aware of. If you look at the market, it's highly competitive at the moment, not only in the US but also in Europe. You have a lot of interest by strategic investors that are now looking to enlarge their portfolio. At the same time, you have private equity investors that consider that to be a very interesting market for the future. And now the specs coming into play in Europe as well. So it's not only US SPACs that are active, but also original European ones. And that has an impact if you have interest, because it means you will enter a competitive market where you have to be very quick to be able to succeed in a bidding process.
Sure. So I'm going to try and draw a corollary to what is currently a fairly out of control housing market, at least that we're experiencing here, where you've got, knowing that we're going to talk about due diligence in the second half of this meeting, the housing corollary to due diligence would be house inspections and things like that, various contingencies that you would have on that transaction. Are you finding that buyers or investors are waiving certain contingencies or waiving certain rights to information ahead of time because of this fast bidding process and the high demand to get into this space?
It really depends, obviously, on the investor. I think you might have the tendency to find very efficient ways how to achieve your goal. Like, for example, as you say, due to the pandemic, usually the internet is still working, so you would then maybe not have a physical inspection, but you see that more often, that you have like robots going through the factory with a camera on them, and you can then get an impression of the factory building like that. Sure. Obviously, you do the interviews remotely, and I think the use of technology is rather the point here, rather than really taking due diligence more easy.
Got it. Thank you. So if you wouldn't mind, just a little bit more on an acquisition, which I think is probably the route that we had envisioned in the first place. I'm certainly going to be expected to bring a lot of information back to my executives. So what are some of the other key considerations that you've got that we need to keep in mind?
Yes, I think a lot of most of the considerations are the same, whether you do a transaction in Europe or in America. The first one being, if you do a share deal compared to an asset deal, a share deal is pretty straightforward. You have the picture in front of you, how the company looks like, what kind of assets you have, the employees you're gonna acquire, and it's an operation up and running, and that will not be affected by the transaction. So that's the much easier way. If you do an asset deal, and the reasons might be various, it might be that you anticipate some possible liabilities or risks from the past of the company that you don't want to inherit. Maybe it's a carve out of an operation from a company, so you just purchase certain assets rather than the whole entity. If you do that, there's much more to be considered, and the key points in the medical sector are obviously permits and certifications, when you have to verify whether these attach to the entity, and therefore you have to reissue and reapply for them, or whether they are attached to the product and the assets you transfer and the operations. Tax considerations obviously are important here as well.
Okay, excellent. So, well, actually, I guess I'll let you expound on that a little bit more in terms of some of the aspects of the contract that will be critical in that acquisition.
Yes, I think if you look at you purchased the company, obviously you want to integrate it into your business, and so what you have quite often is that you would agree on transitional SLAs. If you have either in case of an asset deal, or if just a subsidiary is being sold, so that you get the support of the seller that is required to continue the business. Purchase price, you have the typical provisions here as in any M&A transaction. Maybe that you have to focus more on certain aspects that are typical for medical device companies. Pipeline stuffing, for example, is something you see in all markets, but in particular in the life science sector. Therefore, you have to be careful that you have a provision in the SPA that would provide for that and protect you against such measures of the seller. Yes, and otherwise, representations and warranties, you have the full set as usually as well. In Europe, the SPAs are not the same, but quite similar to the US, because the practice is now to have like a full set of guarantees that are laid down in the contract rather than to rely on statutory law. And so that's why you would also then include specific representation warranties, for example, for certifications and access to market.
Sure. So I understand, in kind of differentiating between, a representation warranty and then an SLA in the ways that you might utilize those. I understand that, in those reps and warranties, you may have, a failure to meet those may be detrimental to the viability of closing of the deal. With SLAs, I'm wondering, what do you usually see or what do you usually recommend from a type of penalties, not necessarily amount, but are you exclusively recommending recommending monetary penalties for transitional SLAs? Let's say for completion of key aspects of in-flight projects that you need the company to continue to develop or work on during this transition period. Do you ever see SLAs with a penalty that rises to the level of not closing the deal if the SLAs aren't met?
I must admit I haven't seen that yet, and I would say the reason is because it's would cut both ways, such a provision, because you already are committed to that transaction, and so yes, it's usually more that you have cash damages, and it's important that they are very specific, and then obviously it's a big negotiation about the amount. I think it has to be substantial so it can be felt, but yeah, to be fair, to be fully protected here, it's that's rather difficult. Yeah.
Right. Okay. Well, thanks for that. So just, those non kind of purchase then related things, right? I know you talked a little bit about labor laws, although I will admit that is something that, that does concern, U.S. companies that are expanding into the European market, the somewhat stark differences that you might see from one European nation to another in terms of labor laws. Anything that you can give us on that would be super helpful.
Actually, you already said everything that is to be said. There are certain aspects actually that are unified in Europe. TUP transfer of the enterprise and protection of the employees. That's one of the aspects here. That means if you, for example, have an asset deal and all assets would transfer to a new entity, then the employees have a right actually to follow as well, so that they would follow the operations and not stay with a company that doesn't have the operations anymore, and then to be laid off. So that's implemented throughout the European jurisdictions. But for example, termination rights and also the participation rights of employees, they are quite different in the various jurisdictions. And so that's something to be looked in, and it's rather, I would say, as you actually are already, you have to be aware that there is a big topic, and that there are big differences in the various jurisdictions. Sure.
One of the things, do you often see, or how do you advise your clients on the topic of, I mean, you touched on it earlier, right? That oftentimes what you're buying when you acquire a company in Europe, you oftentimes are buying its intellectual property, its devices or its technologies, its research, its patents. But in addition to that, you're really purchasing access to those employees, and I know that certainly I've been involved in deals in the past where the human resources in those companies were among the best aspects of those companies. So how do you advise clients that you have that are looking to acquire a company in Europe and want to ensure that they're not going to have a mass exodus of those really critical employees and experts that work for the company upon execution of the purchase agreement?
Yeah, that's a very good question, and would be great to have like the one tool that always works.
Sure.
Like the rather private equity approach for such scenarios, to have some participation of the key people in the capital of the company. I mean, in the US, for example, you would use stock options. In, for example, in Germany, it's yeah, less options, but for key personnel, really like the top level, you would have them to be invested in the equity. And for employees on other levels, maybe phantom stocks, because you don't have the big benefit of stock options from a tax perspective in Europe as you have in the US. But yeah, I would say that's like the one part. The other one is culture, and that's probably where we come back to what we discussed before with doing deals remotely. And that's quite a challenge. Thank God, and hopefully that's over now, the time, and it's possible now really to meet people in person. But I think it's very important that you yeah, are able to bring the people then into your culture and really make them feel part of the team. That's I think more crucial than anything you can pay.
That makes sense, and I will say that that last part, you know, from my experience, is really the key part of it. Is that you know, so often if you value, and I think this is the way that, you know, if we were to move forward with an acquisition, I think we'd have to do this, is if you value those employees and their contributions to the technology and the expertise that the company brings forth, they really need to feel that and have that communicated to them, and also not feel just like a number or a widget that's being moved around as a large conglomerate just starts acquiring everything in its wake. So I think that makes really good sense.
So maybe one other points regarding the employees I put here, because it's like I would say for Americans quite unusual due to the GDPR, for example. You have quite often not lists of all employees in the SPA because that sensible data would be protected. And obviously, that's also one of the aspects to be considered here, that how do you deal with that data protection of the employees, in particular in cross-border situations where the seller is reluctant to have that information being transferred to the US. So that's quite often a little surprise in the process as well.
Sure, absolutely. Yeah, and something that I think a lot of US companies are just not set up to manage, let alone understand intuitively. So that's helpful. So I guess when you think about the process, right? You know, what do you see as the what do you see as kind of the best practices as we move into this? And one of the things that I'm thinking about when we say best practices is really, okay, we've landed on a particular type of transaction. Like, you know, walk me through the steps so that we can easily begin that process.
Yes, I think like if you think about the complexity of an acquisition and what can go wrong, I mean, you have quite often then at one point in time a big surprise about expectations not being met, and these expectations might be on various parts. It could be the expectations of your shareholder then, or the management, or the people involved in the team that would later work with the acquired company, with the sellers, and maybe and obviously also the employees, as we have just discussed. And so to manage that and to be sure that you avoid such unpleasant surprises, I would say the formalized process is very important, because if you really have a strict process and you involve all of your stakeholders from the beginning, then you avoid these surprises. For example, I mean, NDA goes without saying, but if you have the letter of intent and the term sheet, quite often you see that these documents are being treated as, okay, let's do that quickly because it's anyway non-binding. But that's gonna hurt you even at the end of the process. It might even happen at the last point in time in Germany when you sit with the notary, that they would say, but this point actually we had already agreed in the term sheet, and let's go back to that. So I think that's very important, that you have this stringent process, because then you avoid that. What I find very important as well is, and that's my experience also from my in-house time, that you think about what happens after the process. Who is going to be in charge for that entity when you have acquired it? Because these people obviously have expectations on their own, and so it's very helpful to involve them in the process as soon as possible as well. And if you then start thinking about, okay, how am I going to integrate that company, you will have very important aspects that you would then already implement in the LOI and the term sheet, and thereby really have a 360-degree approach to the transaction, rather than going step by step. You can only do that if you have a dedicated team, and I think that's, I mean, self-explanatory, at the same time very difficult, because obviously these transactions are sensitive, and so the team shouldn't be too big. But it's always good to consider who that person, who you will need, because then you can also take into consideration like their normal work that they're doing and how that is going to be affected, and how you can compensate for that. Being surprised as an organization with such a process is quite disruptive to the ongoing business. The use of technology we have discussed. I think as in any aspect of our life, this is developing fast. There are many tools that you can consider, like obviously to have a VDR is now standard, but more and more you can use also artificial intelligence to support with due diligence. And you should also consider using then cooperation tools to make that transaction smooth and fast as possible. And yeah, the legal framework, now the lawyers coming in, that's obviously aspects, as I already said, for example, data protection. You have to consider you will not see the names of all employees too soon, and the competition law would and foreign investment law in particular would play in with the timeline of the transaction, because then you would have the signing and the closing being separated, and with the waiting periods for the authorities to approve the deal.
And so I guess two comments, or one comment, one question. The question, I guess I'll follow up on that last topic. Do you primarily see that, you know, when you've got a transaction where there's, say, a company, we'll say a company in the US is working to acquire, let's say, a German company, you've got obviously attorneys on each side that are managing aspects of the actual deal of the SPA and how that will be structured. But then when you start to talk through these the day-to-day advice that needs to be communicated and probably reiterated and pounded home with the employees in the transition period prior to close and any regulatory approval of the deal if necessary. You know, how do you see the attorney on the German side and the attorney on the US side kind of managing that? Do you see them working jointly? Do you see them individually advising their clients? Is there some agreement that is struck between them, but then they individually are going in order to comply with potentially certain competition laws and advising their own companies? How do you see those two individuals working together?
I would say from a formal perspective, separately, really, like you have the US Council, you have the European Council, but for the client, it should feel like this is a team that is really working closely together, because otherwise that's quite a difficult process for the client. And it would also, like, if you try to sub-mandate then the lawyers and somehow to bring that all together, that it only works if you have a very good team that can work closely together. And that applies whether it's separate law firms or it's the same law firm, because this is a question of culture and how you do your work, if you really are a team player or not.
Right. Okay. Thanks for that. And the one comment that I guess I would add, again, you're the expert in this field, but in my experience, I couldn't reiterate enough your comment about the LOI and the term sheet being an important step that tends to get overlooked or tends to get less emphasis placed on it, where people say, well, this isn't the deal anyways. It's just us talking about the deal that will happen at some point in the future. And the fact is, LOIs and term sheets continue to come back. They continue. You'd be surprised at how on the top of the CEO's desk those types of documents continue to stay and how familiar that they get with them. And so I think you're right to say that put the work in at the front end, even if that's not the binding deal that will get closed, or the binding document that will get closed. You're going to save yourself a lot of pain if you put in the work on the front end on both of those.
Absolutely.
So can you just talk, we've talked about, this is obviously coming from a wealth of experience that you've got, what kinds of examples do you have of what the transactions that you've helped your clients perform and some of the, the wins that you've been able to achieve for your clients in those?
Maybe because also I see we don't have so much time anymore. Quickly, I think what is quite interesting in the MedTech sector is that you see quite a lot of transactions with very different players. That you have like the huge corporation, international, very experienced, and then you have maybe a very small venture capital funded entity. You have then, for example, a lot of shareholders that would become sellers, and you have to consider how they would then interfere with the process that you think would be very easy and straightforward. We have seen the impact of COVID, obviously, which was not as material as anticipated. There was like a few months where it was quiet, but then it picked up even more. So I would say again, like the key points we already discussed. For example, this carve-out acquisition, that is something where you have to be careful, because there you get involved in a quite difficult transaction where you have to separate assets and operations out of the existing company. And before entering into such a transaction, you should place even more work in the beginning to have a clear picture than in other transactions. Otherwise, I would say we have covered all of the particularities of these transactions. Yeah.
Well, excellent. Well, like you said, we're getting we're running a little long on time, but I guess any of the first steps here, and then I think maybe a few final takeaways would be really valuable.
Yeah, I think this is rather a summary of what we already discussed. Like really have that clear picture of what you want to achieve in front of you. Then work at the beginning, define a strategy, contact your stakeholders, set up the team, and then actually then you start with the transactions. Like finding the target obviously is I would say nowadays the most challenging part, and then you start with the transaction as we already discussed. But this is like a little bit how I would see what I would recommend to your board as the next steps.
Excellent. And then, you know, I'll kind of leave the floor to you. I think, you know, this is the way that you presented this. I think I'm pretty well convinced that this is the right thing to go back and discuss with my executive committee. Executives tending to have a fairly short attention span. I kind of need a few dedicated bullets. So what are your primary takeaways that you think are necessary for me to take into that discussion?
Now I'm definitely repeating myself because it's really that point. The final structure that you have in place, that you have in mind, really prepare at that and have the team. I think this is definitely the main takeaway. And if that is met, everything else will fall in place.
Well, excellent. Well, thank you. That's a fantastic summary of, I think, what is critical, and I'll be honest, there are quite a few of those of the items that you raised that you know, are really unique to participating in these types of transactions in Europe, as opposed to some of the transactions I'm more used to that are entirely domestic within the United States. So I appreciate you sharing that with us.
You're welcome.
So from there, we're going to jump into a quick walk through some of the considerations that we should have in due diligence in medical device transactions. As you see, as I walk through, I'll talk about kind of the assumptions that are built into this. The thing that I want to say at the outset is due diligence, it can take a lot of different forms. The directions it goes, or the arms or tentacles to it maybe that it has, can really vary based on the type of transaction you've got, based on the type of industry that you're in. I mean, even within life sciences and med tech, there are various arms that can grow onto your due diligence monster as you are looking to begin the process, and there are really various areas of focus that you may have depending on the structure of your deal. So I'm going to walk through kind of the way that I look at due diligence, the way that some of my colleagues here at Gardner provide, in particular, compliance due diligence activities and expertise, and the way that we think about how that works in a deal. So the first thing that I'll say is, you know, due diligence, to me, it's too overwhelming of a topic to consider just all at once. It's got to have work streams, and obviously there are formal work streams, right? You actually have, as Andreas talked about, you've got individuals that are managing, you know, each of the interactive work streams, whether it's with individuals at a target company, for example, for acquisition, whether it's managing certain aspects within a clean room, whether it's managing certain aspects with a third party that is performing due diligence on your behalf. But one of the things that I want to highlight is, you know, when we think about due diligence, a lot of us think about the purely business aspect of it. We also think about the compliance aspect of it. We're obviously going to focus on healthcare compliance here. We're also going to talk today about regulatory compliance and what that means when considering, for example, an acquisition of a medical device company. So business due diligence is neither my area of expertise nor the thing that I think we're here to focus on today, but I would just say that there are certain aspects of it that are going to bleed into or affect regulatory and compliance due diligence activities. So obviously we just talked about deal structures. That's, that the corporate structure is going to in part dictate at least what your opportunities are for deal structures. The financial fitness of the organization, I'm assuming that is the first thing that you looked into when you began these discussions with your target company. Intellectual property, which Andreas also touched on, it's important to know, what your intellectual property rights are of the target company, and where those intellectual property rights are going to be enforceable. And then additionally, as we talk about that kind of human capital of acquired companies, it's really important to think about what inventions and developments by employees and contractors or third parties generally, what those contracts look like, because what you don't want to do is assume that everything that was created under the roof of a target company is going to be part of the acquisition. An evaluation of customers, contracts, distribution, that is all part of standard due diligence. Litigation, either active litigation or any threatened litigation. Employment matters, which we touched on before, and then potential product liability issues, which I will address a little later, because I do think that actually inadvertently bleeds into regulatory due diligence, which is the next topic. So, what we're going to talk about is what is regulatory due diligence, why perform it, and the question why perform regulatory due diligence is really another way of saying what can go wrong if you don't perform it or don't perform it effectively. Who plays a role in it? So what's the team look like, the team makeup? And then how does the status of a device change regulatory due diligence activities? So do you merely have a technology? Do you merely have a proof of concept? Do you have a device that has regulatory registration, approval, or clearance in one or more jurisdictions? Do you have a device that is ready to go to submission to a regulatory authority but has not yet been reviewed? So we'll start here. My father being a large fan of American Western films, I was able to maybe make a little tie to one of his favorites. So there's a good, there's a bad, and there's a particularly ugly aspect of why you're doing regulatory due diligence, right? The good is you're doing it to ensure that you're getting the product that you want and that you're going to be able to make the claims with regards to that medical device that you want. You're evaluating that it is what it's being represented to be, both in the marketplace generally and to you by the target company. And also with regards to claims, it's not just those claims that are being made by the company at the time that you acquire it, but due diligence gives you an opportunity to evaluate data that the company has on file, whether it's from ongoing clinical trials or clinical trials that it's performed in the past and has reports of, which may give the basis for the evidence necessary to seek new claims for that device. The reason that you're doing due diligence or the things that you're doing it to avoid is that you don't want to end up getting less than you bargained for. And you don't want to end up in a place where the housekeeping is so poor with regards to the regulatory files, the quality files, the compliance activities that you're faced with remediation. I have seen that play out, and I have seen it cost a company significantly more money to make that acquisition than they thought, than what the purchase price was, because upon purchasing it and not having enough information about for lack of a better term, the housekeeping in the quality files, there was a whole slew of remediation that needed to occur and resources that needed to be devoted to that. The particularly ugly then can rise to the level of market withdrawal, right? Another thing that we'll see is occasionally you'll have devices, and particularly thinking here in the U.S. regulatory framework, for ease of discussion, a device that has been classified by the company that's being acquired as one that's exempt from pre-market notification rules means that it's not necessarily had the eyes of a regulator on it at all. That doesn't mean that it is legally placed into commerce, because the assessment had to be a correct one. You may find yourself in performing due diligence, you may find yourself reviewing a device previously commercialized, maybe extremely profitable, that is misbranded and has not received the pre-market clearance necessary to distribute it legally. Additionally, you may, and this is where product liability can kind of bleed into regulatory due diligence, is you may find that there are recalls that are necessary now, or there are recalls that there are signals in the data that suggest that there may be one on the horizon, or at least that investigation needs to be done internally, and that may additionally have product liability considerations. So when thinking about regulatory due diligence, it's not necessarily just the people that you might think that need to be at the table. So you obviously have your regulatory folks, you've got your attorneys, you've got, clinical is going to be critically necessary, and so medical directors and quality. You never hear anybody talk about quality due diligence, but it really happens within the context of regulatory and compliance due diligence. Engineering is obviously going to be critical because you're going to be evaluating the design history file of the device to ensure that it is what they have represented it to be. But then where it might get a little interesting is your sales and marketing team, I think, is one of the most critical people here. For those of you on the line that may be in sales and marketing roles or may interact with them often, there is often a tension, ideally healthy, but not always healthy, between your sales and marketing teams and your regulatory, legal and quality teams. And the reason that I think it's really important to have them at the table is one of the things we're looking for when people think about due diligence, we all think about protecting yourself, right? We all think about you are trying to identify what potential landmines there are or pitfalls there may be, that you're not going to that you may not have an eye for. The other part of it, though, is it may turn out that you are looking to acquire a company with a technology or acquire a device that actually a very conservative approach has been taken, and that the sales team and the marketing team, they may be able to communicate that, we want to be able to go out and claim X about this device. We may be able to get more claims, use it in different circumstances, potentially seek additional indications or populations for which this may be prescribed. And so it's important to know not only what you've got, but whether or not you're going to be able to get your best case scenario, and the sales team tends to be able to help you get there. So I mentioned there's all these variables that impact regulatory due diligence, and I'm going to, for our purposes, being a US-based attorney and regulatory professional, I'm going to focus on a US company that is acquiring another, it may be a foreign company, but acquiring another company and looking to commercialize or continue distribution of a commercial product in the US market. However, let's not forget that can be, that can take a lot of different forms. It can be, like I said, technology or proof of concept versus an actual commercially available device. You may be looking to distribute solely domestically, or you may be looking to distribute internationally. I'm going to look at this from the context of I want to immediately distribute this device in the US. And then, there may be devices, you occasionally will see devices that have kind of different iterations, right? the same device, or maybe the same device with certain additional kind of add-on devices may be available for different indications or under different approvals. We're going to focus on just a single device with a single indication here. So regardless of whether or not you've got a technology alone without any regulatory approvals or clearances, or you actually have a cleared or approved device that is already on the market, it's important to look under the hood, and that's what a lot of this is. You know, regulatory due diligence, you'll also hear people talk about it as engineering due diligence, and because it's really an evaluation of the design history file, of the engineering associated with the device. It's also the clinical evidence, right? And understanding clinical, as certainly as some of my colleagues here at Gardner can attest, clinical it's a tricky subject, as a lot of you know. Not all medical device companies have a great feel for what the impact of the endpoints of their clinical trials, or the inclusion and exclusion criteria of their clinical trials, of the impact that those will have on the ultimate ability to market the device, or the limitations on the marketing of the device that they may have. And so really important to pore over those things. And you know, I really recommend to people that they look at it with fresh eyes. I mean, that's how I think due diligence is supposed to happen anyways. But, you know, to the extent that your team that you've established and given seats at the table, to the extent that you can convince them to look at things with fresh eyes and without any of the assumptions that they had about the device or company beforehand, I think the better off you're going to be. And then I think it goes without saying, right, an evaluation of the testing that's available, ensuring both that it's adequate and that it meets the requirements that it purports to meet within the design history file. So looking at this then from a purely pre-market perspective, so we're looking at this, it's a device or technology that's not approved or cleared yet for commercialization. You know, the goals that we've got here are a little different. We're evaluating the viability of the device or the technology. At this point, we are assessing the probable regulatory pathway, and we'll discuss regulatory pathway very briefly in a moment. This certainly isn't meant to be a training on regulatory pathways, but I think it's critical to understand at least the basics of that if you're going to go into pre-market due diligence. And then establishing that regulatory strategy, which is different than the pathway itself. Including, for example, for a class 2 device that requires 510K pre-market notification, evaluating the existence of potential predicates in the market, and if not, contemplating whether a de novo approach is going to be necessary. There are a couple of implications of that, primarily timing and cost. And then really just assessing that runway to approval or clearance. Those are the main goals that you've got. Or that you should have in mind if you're in a pre-market setting. On the other side, you've got a commercial product, and I think the goals, the first goal is the same, right? Evaluate the viability of the device, therapy, or technology. And this goes back to that comment that I made, that we shouldn't be, we should get rid of our preconceived notions about the device or the company going in. Evaluate it as if you're evaluating it from a is it viable or is it not perspective. Because you don't want to have any assumptions on that topic or rely on the work of the previous company, most critically because in this space, it is very common, as I'm sure most of the people on this call are aware, it is very common for a company to have basically been started and a technology to have been brought to market or to proof of concept with the primary goal of being acquired. And so if you were to rely, or if you were to assume reliability of all of the conclusions of the company that had gotten it to that point, there's a little bit of a fox guarding the hen house situation going on that you're gonna want to keep your eyes peeled for. In addition to that, you're going to want to dive into the regulatory reviews and communications. The submissions, if to the extent there is an approval or clearance, you're going to want to understand those. That there are going to be certain limitations on that. There may be certain ongoing obligations. You may have a post-market study that's required. You certainly are likely to have post-market surveillance activities associated with it. And so just understanding your particular obligations is important. And then this kind of goes back to that first point, but evaluate the regulatory status independently on your own, right? And this goes back to the idea of you purchase a device that's been on the market and is profitable as a class 1 device exempt from pre-market notification, and you determine in your own independent regulatory assessment that in fact it is appropriately classified as, say, a class 2 device requiring pre-market notification and FDA clearance. Don't rely on that other assessment that may have been done for purposes of speed to market, because you're going to be the one that's carrying the risk if you purchase that. And then finally, it's the goal of it is to not have any surprises. Having been at a company that had at least one acquisition and then post-close had a number of surprises on its hands that it really didn't identify. It was really based on assumptions that the company had about the device and the technology. It's important to make sure you come out of it without any surprises, because I think the due diligence team is appropriately should be held responsible for not recognizing those potential surprises. So, like I said, not a training on device classification or approval or clearance, but it is important to evaluate. I mean, this is the heart of regulatory due diligence, is ensuring that the device is classified appropriately, that it has met all of its requirements under the statutes and the applicable regulations. And I think one of the things that I guess I would highlight is, particularly for a company that commercialized a product a relatively long time ago or several years ago, you do see FDA is issuing rules less commonly, but guidances more commonly. And while those may not be formally binding, they will regularly have an impact on your device, including potentially whether or not you've classified it correctly. So making sure that you understand the risk-based classification structure of the FDA, making sure that you have followed the appropriate U.S. regulatory pathway, whether it's from a PMA all the way down to an exempt device that doesn't require pre-market notification. And then the other thing is, and again, this goes to that field team, whether it's the sales and marketing team, or whether it's other people that are seeking input from healthcare professionals. Understanding whether you'll change the device and understanding what the impact of that will have or could have on your regulatory status. So, for example, for a 510K device, you may be making small changes that don't amount to the creation of a new technology. They don't impact the indication, and ultimately the device continues to be substantially equivalent to its predicate device, and therefore does not require any more proactive review by FDA prior to commercialization. On the other hand, your team may say to you, the reason that we're purchasing this device in the first place is because we want to tweak it in order to interface with another device that we've already got on the market. That's a fairly common strategy. Those tweaks can oftentimes rise to the level of requiring additional regulatory review. Knowing what the end product is supposed to be, or knowing what the business goal is of making the acquisition, is critical to understanding what your runway is going to be between today and commercialization of the end desired product. The review of the regulatory file is the real activity. It's the meat of the activity that you're going to be doing within regulatory due diligence. You're going to want to be evaluating the completeness of the file. And I should say, when I talk about regulatory file, that's an amorphous term, and it's certainly not a capitalized term by any means. What we're looking at is, I talked about regulatory due diligence incorporating quality due diligence and engineering due diligence. And risk, I should say, as well. It's all of those. And then it's additionally the completeness of the file in terms of all of the post-market activities or all of the post-submission activities that have occurred, whether there are letters to the file on a 510K device that's had minor changes over the years since its commercialization, whether there are assessments of the minor changes to a PMA device, which may require you to do an analysis as to whether or not any of those would have required FDA submission. And so it's really just evaluating the life cycle of the device from the day that it was introduced or put on the radar of FDA to the product that's available today. You're going to want to review communications with FDA. I can't tell you how common it is that in doing, and this particularly will come up in copy review or ad promo review for a medical device company, where there are these nuances around what is and is not appropriate for the labeling or for marketing. And to an untrained eye, it may seem that using a particular word is not offensive to the indication. It just aligns with the indication. And yet there is a specific communication that the company had with FDA, wherein FDA said, we don't like the fact that you use this word. We think that your indication should state this. We don't think that the labeling is clear enough on this topic. I think you should add this particular explanatory phrase. And that really creates something that you need to rely on and that you need to continue to, that is FDA planting their flag in the sand and saying, this is, you can't cross this particular line. And so it's really critical to have an eye on that. Obviously, the product clearance or approval, that goes without saying. As I said before, make sure that the regulatory assessment that you're doing is an independent one, not relying on what the target acquisition company had determined. And then, like I said, design changes that have happened over the years or that are planned, just hugely critical to evaluate. And they may be the difference between having a product that is legally placed into the market or not. This is, I think it's important to note the reasons why we're doing a lot of this, right? At the outset, I would say, the easiest way to communicate what the reasons why you need to do this is that you can end up with Form 483s, you can end up with untitled or warning letters that are communicating that you've got a product that is that is not legally put into commerce. Other things that can come up, though, there's a variety of different compliance correspondence mechanisms that FDA has. It can impact your ability to import devices. There are, recalls that are associated with this, debarment or disqualification from federal programs, which obviously can be a death knell for certain small companies. Certainly, civil monetary penalties. Some of this can be associated with criminal prosecution. We'll get into some of the compliance aspects that are more associated with that. But false claims and anti-kickback statute, will subject you to criminal prosecution. Consent decrees in some of the worst cases, including and as well as restitution and disgorgement. And just a comment that I do think, and this may be the conservative approach, but I think it's important to note, regulatory due diligence continues post-transaction. So the concept of regulatory due diligence is a holistic activity. It doesn't have to be limited to just in the context of a transaction. I believe that the regulatory and the design history files for devices should be considered on a semi-regular basis whether it's that the devices undergo changes, or whether it's that regulators thinking has evolved, and like I mentioned earlier, a new guidance is released, or new rules were promulgated that are directly applicable to your device and undermine the regulatory decisions on which you have based your ability to market the product. And then the last thing is post-market surveillance, which must be done even outside of this context. But the post-market surveillance for your device, sometimes your competitors' devices, or particularly say a predicate device that your device may be even more formally tied to, and literature, keeping on top of those things. I think the best practice that I can recommend is that regulatory due diligence is an ongoing activity. Knowing that we have 14 minutes left and I want to leave time for questions, I'm jumping into compliance due diligence. I'm going to do this fairly quickly. What I would say is the context of this is, we at Gardner, and really a number of my colleagues here at Gardner are compliance experts. They're doing this for our clients, and whether it's on the buyer or the seller side, we're available for that. And I think one of the things that I want to highlight in here is how I think you should think about compliance due diligence when you are looking to acquire. So I'm going to go fairly quickly. I'm certainly not going to read the litany of U.S. healthcare compliance authorities that are applicable to this, but what I would say is it's expansive. This is by no means an exhaustive list, and it's important to have an eye towards all of the various rules and regulatory authorities with which compliance needs to be, or for which compliance needs to be demonstrated, and the significant impact it can have if you don't. I was able to reuse Clint Eastwood here, you'll note, so that I didn't bore you. I have switched the slide around, so you're welcome for keeping you entertained. But the purpose of it, right, the good, the bad, and the ugly, kind of similar, but it can be, I think it mostly cuts more in the negative direction, right? So the good, compliance is something that has to be done, and you're less likely to. This is not the area where you're finding new claims, for example, like when I was talking about in regulatory. Within compliance, the best thing that can come of this, and this is critical, is that you can hit the ground running and you don't need to go back and fix a bunch of things. But really, it's the bad and the ugly that we're trying to avoid when it comes to compliance due diligence. The bad may be that you identify something early enough that you may have a change in your acquisition strategy. That may end up in a write down on cost, but it also may end up just scuttling the deal altogether. The ugly is that you don't catch it early enough and you inherit liability, and there's a significant amount of liability that can be inherited here. The best way to approach this I think is to look at HHS Office of Inspector General, the 7 fundamental compliance program elements that have been set forth. Again, I'm not going to read through this in the interest of time, but the fact is, this is the context and the structure in which we recommend doing this. So the fundamentals are, and what I would do is, I'm going to jump to the end of this slide and say, how do best-in-class organizations establish their compliance programs? I actually think the best way to begin due diligence from a compliance perspective is to turn your eye towards the model compliance program and the ways in which a compliance program may be best set up, and then compare that to what you're looking at. So, the establishment of a compliance officer and ideally a compliance committee that are engaged in oversight and the flow down of compliance rules. A network of policies and procedures is absolutely critical, which I'll talk about in a moment. Some key established protocols regarding training, regarding the availability of a hotline, compliance meetings, whether it's that committee or whether it's broader within the organization, the expeditious implementation of corrective actions to the extent that non-compliances are found. The use of third parties or even internal parties, but third parties tend to be a kind of a gold standard for mock audits. And then ultimately, this phrase that gets just thrown around a lot, and I think for good reason, but the culture of compliance. And I guess the way that I would describe that is, if a regulator or an authority is going to identify something that has been done that is not in compliance with law or regulation, the thing that can remove that can take that from say a rogue salesperson and can remove that to organizational responsibility is the failure to have done a lot of the things that are on this page, a lot of the things that are within the 7 elements, which are evidence of a lack of compliance. And what you actually want to be able to demonstrate to a regulator is that you are fostering a culture of compliance, which is, if not a formal defense, still an excellent defense to one individual's non-compliant activities. I'm not going to read this, but what we at Gardner have done is establish kind of those most critical policies and procedures that best in class healthcare organizations have in place. As Freya said at the beginning, this deck will be available to you, and so I'd encourage you to review this as well as kind of other things that might be available. Other policies and procedures that you might make available to demonstrate a robustness of your compliance program. I think one of the things here I would just say is, when we're evaluating from a due diligence perspective, when we're evaluating a target, the first thing that you want to do is, you've got kind of these data requests that you're going to have, right? You're going to have interviews, and I think you're going to have in the back of your mind that culture of compliance as you're performing your interviews, and that goes not only for those most senior individuals within the compliance function, but then within other functions in the organization. But then after that, what I think is really good to do is to pull on particular types of engagements. And on this slide, you see several of them, right? You see a speakers bureau, you see pricing and discount programs, booth conduct, right? When you can in an interview for due diligence purposes, for compliance due diligence purposes, when you can ask somebody about specific types of arrangements and how you engage in those, and you can get a positive answer back that demonstrates that compliance was woven into that, I think that's one of the best indications of a compliant organization. Again, I've stolen this from one of our best practices. I think looking at how you would best set up a compliance program, and some of these, the punch list example of these are the things that you should critically do at the outset to set up a compliant program. These are going to be valuable for you to look through when we have more than 7 minutes left until the end of our training. And then at the end of it, what you do is you compile information, you interview, and you assess, right? And these are some of the considerations that I think should really be taken into account when you're doing that. So I think the key takeaways, very briefly, is it's important to set the table correctly and get the right individuals at the table from the get-go. Having buy-in from them is going to make the whole process a lot more easily. On a regulatory side, you want to know where you are. You want to know what the device is right now. You want to know how you got here. So you want to know that the device went through the appropriate regulatory pathway and sought the appropriate clearance or approval to get there. And you want to know where you want to go, which is, what's the work that we're going to need to put in to get this device? If it's not already commercialized, what's the work that's going to be to get it commercialized? If we want to commercialize it for a slightly different purpose, for a different indication, if we want to commercialize it but with certain technological tweaks, what do we need to do that? I think it's important to be dynamic. So medical devices change, regulations change, and regulatory strategies change, and that's why you just go in with a fresh eye. When it comes to compliance, focusing on that culture of compliance is key. And then having a list of strings available, right? A couple of slides ago, we didn't go through in depth, but there are these areas that if healthcare companies screw up when it comes to compliance, There are some areas they tend to do it more than others. Be knowledgeable about those particular areas and pull that string if in your interviews you start to get there, or if in your data requests you see documents that suggest that. And then finally, compliance is best demonstrated in companies' worst moments, which is to say that corrective actions, for example, if companies are quickly implementing them, if they're acknowledging errors and they are implementing CAPAs in an effective way, for example, I actually find that to be a demonstrative of a positive culture of compliance, despite the fact that they may have had some hiccups along the way. And finally, just it's got to be acknowledged, like Andreas said, sometimes you get to the deal and people just want to start signing on dotted lines. Failure to give appropriate attention to due diligence is something that companies pay for.
Yeah. Quite often the deals you don't make that are the best. So unfortunately for us, but I think that's you have to keep that in mind, and this is why you have to do the due diligence.
Right. So with that, understanding that we only have a few minutes left, Freya, I don't know if we got any additional questions in that you'd like that you'd like to share.
We don't have any additional questions. We still have the question that I think to the most extent you have answered. Should I read it again though?
Yeah, no, I mean, I guess, yeah, if you wouldn't mind reading again, I think I can reiterate kind of the response.
Of course, and to all the other participants, you can always use the question pane on your control panel to ask more questions, and I will read them aloud. So the question was, are there specific questions that are valuable to ask during due diligence?
Yeah, and I think that I think that goes back to, like I said earlier, in talking about culture of compliance, right? That there's not particular questions that will get you there. You're gonna get that over the course of the interviews. But I think it is. It's asking about very specific arrangements, about participation in very specific types of sales activities, and kind of letting the interviewee expound on how they go about those activities, right? It's not the policy and procedure questions aren't going to get you as valuable information in a due diligence interview as the how do you do X, when X is an activity that you know to be rife with risk for compliance issues.
Thank you. So we do not have any more questions, which could also mean that you just covered everything very clearly and well. So it's a great sign. And also, if any more questions come up after the webinar, often that's the case, you can just get in touch with Andreas and Jesse. The addresses are here, and you will also be sent the presentation afterwards.
Great. Well, thanks so much. Thanks to everybody that attended, and Andreas, as I mentioned, fantastic working with you, and we at Gardner are lucky to have Field Fisher as a partner to do these activities with. So thank you.
Jesse, same here from us. Always a pleasure working with you guys, and yeah, was great. And I hope we have another opportunity to do something like this again. Freya, thank you for moderating this, and everyone stay safe. Thank you.
Excellent. Thanks so much.
Thank you all.